I guess somebody remember Senator Allen. Since you took the legal point, I was wondering about this. I heard the term compelling state interest. And being a Marine, a guy who shoots guns, I'm not really into law stuff, but a compelling state interest. I understand for compelling state interest, the states have to prove that to impact upon an individual's freedom. And in California, we have a constitutional right for education. So explain to me from a legal perspective the compelling state interest to implement this law to impact upon a parent's right for education for their child, which is a constitutional right. I'll follow on to my other lawyer after you answer.
Okay, well, it's a great question, and I think ultimately, it's at the very heart of this discussion. So this compelling state interest that was in this right to education is codified in Serrano v. Priest decision in the early 70s that actually came out. It was a school finance case that looked at the fact that we had tremendous disparities in how we were financing school districts from region to region that helped, that mirrored the disparity, the poverty and the economic disparities that existed from one area to another. And the court finally threw out that entire financing system, saying that we weren't offering equal protection to students based on the fact that they were growing up in a place of poverty, in a place where there was socioeconomic disadvantage. So the question becomes, is this bill necessary to achieve a compelling state interest? And the courts have said over and over again that the protection of public health is absolutely a compelling state interest. And they've said that specifically with relation to vaccines. The Phillips case that I mentioned I only mentioned it because I have a long list of cases. I only mentioned it because it literally came down this year. There are actually two not as recent but pretty recent cases. Fourth Circuit Workman case, Brown v. Stone in Mississippi, that both upheld bills that were much stronger, actually stronger than 277 in their respective states, on both First Amendment, both on First Amendment and 14th Amendment grounds. So the question we have as a legislature now is, hearing all of the issues here, hearing the public health implications at play, is there a compelling state interest? Our public health officials tell us unequivocally that the answer is yes. That's up to us to decide. I certainly have listened carefully to the science, and I feel as though there's a compelling state interest. But that's a determination for each and every one of us in the legislature to make. Whether the case has been made that there is a compelling state interest to take this sort of action. Now, of course, let's be clear. This does not deny children an education, but it certainly does restrict parents' options. There's no question about it, and I'm not going to try to mince words. But there are other options that will exist. Obviously, we've talked about homeschools. Obviously, we've talked about this independent study mechanism. I think that the amendment that clarified the fact that nothing in this bill should impact the ability of a kid to get the full program afforded to them in their IEP is an important change that I very much welcome. And so those are things that will certainly that mitigate against the idea that this is unduly restricting a student's access to education, but this is certainly a restriction, and this is the determination we need to make, whether we've met the grounds for a compelling state interest. I think we have, but you may feel differently.
Thank you very much. And sir, would you like to comment? This will be my last question.
Thank you for the opportunity. Again, with all due respect to Senator Allen, the first case that he cited, it was a law that did specifically allow a religious exemption and some degree of parental right. I think he also, let me please finish. I think he also is quoting a case that was decided under Mississippi law, which I'll just point out, California affords very different set of educational protections than the laws of Mississippi. The analysis that the court does, I'm a student of this and I teach this educational law analysis. So the analysis that the court does when you attempt to limit or deprive a fundamental right is a very specific one. The court will not look at, is public health a compelling state interest? In this case, the court won't even look at, are vaccines a compelling state interest? It's a narrow analysis. And what the court looks at is there a compelling state interest to remove the personal belief exemption in light of what's going on? So that's the first prong of the test. I'll point out again, no court has ever found under California law a compelling state interest to deny or limit any access to publication. It's a two-part test. The second part of the test requires a finding that the law limits the right, the fundamental right, in as narrow as possible way. And existing law already provides that opportunity. Under existing law, if there's an outbreak in a specific district or community, the school board has the right, without any additional legislation, to temporarily not allow certain students who aren't fully caught up on vaccines from attending that school. So that's an example of something that's narrowly tailored. Another narrowly tailored example would be if there's a pandemic outbreak in California for a specific disease, a court might find that mandating that students receive that vaccine could be narrowly tailored. I know that the author talked about the likely litigation that will ensue if this bill is passed. The ACLU has sent a letter to the author raising the point that I raised about compelling state interest. Given the disproportionate negative impact that this bill would have on Black and Latino students, and especially in light of the recent admission that the CDC had ordered its scientists to withhold information showing that Black boys under 36 months were much more likely to develop autism if they received the MMR vaccine within the first 36 months. Given those pieces, it's likely that organizations like MALDEF, NAACP Legal Defense Fund, disability rights group throughout the country, in addition to all the parental rights groups and individual students, and the state will be mired in waves of class action litigation to stop this law from coming into effect.
Well, thank you very much. Senator Allen, did you want to?
Yeah, so a couple things. First,
I was just going to cut it down because I'm trying to get on.
Yeah, no, I know. And just with respect, two critical things to mention here. First of all, the other cases that I mentioned actually did involve a religious exemption, and the courts. There were situations where a religious exemption did not exist, and the court said that was okay. That's the first thing. The second thing is the ACLU did raise concerns. It also raised concerns to say that just because your rights to make choices don't trump the rights that I have to make sure that my kid can be safe in school. And the final thing I'll say is that, unlike in the case of Serrano v. Priest and all of the situations that you're talking about that involve distinctions that are difficult to get out of, people. In this case, we're talking about a choice that's been made by a parent not to vaccinate. It's not it's not an inherent quality that existed in all of the civil rights discrimination legislation and litigation that Serrano was part of, including the wealth distinction.
Well, thank you very much. I'll just close with this comment. Truly, this discussion we're having here is not about vaccinations. I think it's about freedom. I think somebody used that in the beginning. It's about freedom. I'm looking at this and trying to figure out, before I impact upon people's freedom, what is the problem? What's the problem we're trying to solve? And the fact sheet I have here from the California Department of Public Health says very clearly that implementation of statewide requirements have been effective in maintaining a 92% immunization coverage among children in licensed care facilities and kindergartens. So even our own state recognized that. So I'm just wondering, what is the problem? I haven't made my mind up yet, but I appreciate the discussion on this.
I don't think that was rhetorical. Did you want an answer from the author, or? No. Oh, that was a statement.
That was a statement.
Okay.